Okay, I'm going to talk about the Antitrust Division's corporate leniency program. And to begin, I want to say a little bit about what we do in the Antitrust Division, which is our primary focus is on prosecuting cartel conduct, which is price fixing, bid rigging, and various types of market allocation, such as customer and territory allocation. This is conduct that occurs in secret. It typically occurs behind closed doors, and even the victim doesn't know that it's being victimized because cartels happen in secret. So because of this, it was important for us to develop an effective tool that would enable us to detect cartels and prosecute cartels, given the secrecy in which they operate. So in 1978, some division prosecutors came up with an innovative idea, and that idea was the corporate leniency policy. And the concept of the corporate leniency policy is that the Antitrust Division is willing to forego prosecuting one company in a cartel in order to get that company's cooperation. And so if the company is willing to come in, fully disclose its involvement in the cartel, self-report what its involvement was, and cooperate with our investigation against the other companies and the other individuals involved, then we're willing to forego prosecuting that company. That means we don't charge the company criminally and the company is not fined. And in addition, the individuals who are working for that company, the directors, the officers, the employees, under our current corporate leniency policy, are able to also get leniency if certain conditions are satisfied. But I want to discuss how we got to the place where we are now in terms of the corporate leniency policy. And in 1978, the policy that was developed then did not have all of the characteristics that I just mentioned. And in fact, when we adopted that policy, it turned out that very few people, very few companies applied. As a matter of fact, during the time period when that policy was in effect, from 1978 to 1993, the division typically received only one application per year. So, in 1993, the division decided that we needed to revise the initial policy. And there were three ways that we revised the policy that made, frankly, a very significant difference. One way was that we put in the policy that if a company came in and told us about a cartel that we knew nothing about, we had no idea that cartel existed. If they did that and told us about a cartel that we didn't know about, that company would automatically get leniency. That was change one. Change two was that if a company came in when we did know about a cartel, we had opened an investigation to look into that cartel. We had served grand jury subpoenas to get documents from companies about the cartel. Nevertheless, in that situation, under the policy, the company could still get leniency if it satisfied certain conditions. And of course, in both of these situations, it's very important to note that the company is required to fully cooperate with our investigation in order to get leniency. And that means that the company is expected to conduct an internal investigation to find out the extent of the illegal conduct. The company is expected to provide us with documents, and if those documents are overseas, they're expected to provide us those, and if they're in foreign language, they're expected to provide us translations. They're expected to provide us access to witnesses. So there are a number of requirements that we impose on companies that are cooperating, and they have to satisfy those requirements and fully cooperate with our investigation. And then the third thing that, the third change that was made, number 3, is that employees were able to get leniency. Employees of the company that was coming in to get leniency were able to get leniency if certain conditions were satisfied. So those 3 aspects were the changes that were made in 1993 and constitute the basis of the current policy that we have today. So what happened after those changes were made? Well, as a result of those changes, companies now had a greater incentive to come in and to utilize the corporate leniency policy. And as a result, the applications increased dramatically. Instead of 1 a year, by about 2003, we were getting 1 a month, so 12 times as many applications per year as we had previously gotten under the 1978 policy. And then by 2010, it was about 20 times as many applications as we'd received under the 1978 policy. So the bottom line is this, in fact, the corporate leniency policy turned out to be the effective tool that the prosecutors in 1978 hoped it would be. And it is now the most effective tool we have to detect and prosecute cartels. And in fact, it's so successful that it's been adopted by many jurisdictions around the world. Around 80 jurisdictions now have some form of corporate leniency policy, and those policies are different in many times they're different in some respects from our policy, because the law in the jurisdiction is different, the customs are different, the circumstances are different. But those policies are based on the Antitrust Division's 1993 policy. And in fact, one of the jurisdictions that has a leniency policy is the Malaysia Competition Commission. It has a corporate leniency policy based on the Antitrust Division's 1993 policy. So one thing that people ask frequently about the corporate leniency policy is, how do you make the corporate leniency policy effective? What do you need to do to make sure that if you have a policy, that it's an effective policy? Well, we have a lot of experience with that now, of course, and we feel that there are really 3 cornerstones of an effective corporate leniency policy. And one is that the policy has to be transparent and predictable. It's really important that those things are true. And this is something that we're constantly monitoring to this day in terms of the decisions we make with respect to our corporate leniency policy. We want to make sure that whatever decisions we make, it doesn't undermine the fact that we've established a reputation for the policy being transparent and predictable. And in fact, we recently posted some FAQs, frequently asked questions, that have updated answers from the prior version of the FAQs, which were posted a number of years ago. And the point of doing that was to make sure that those answers are a reflection of what our current policy and procedures are, so that we can maintain transparency and predictability, and that we continue to focus on that and make it something that is something that we will continually do as the years go by. So the other thing the other 2 things actually that we think are that are cornerstones of an effective corporate leniency policy are fear of detection and adequate sanctions, sufficient sanctions. And those two really go together, because the company has to feel that there's a likelihood that its conduct is going to be detected, and it has to feel that if that happens and the conduct is detected, that it will be subject to severe sanctions. So those are both important, and it's important that we have both of them. If you only have one, it doesn't create the incentive for the company to come in, because it's concerned that its conduct will be detected, and that will result in severe sanctions. So with respect to detection, the question is often asked, well, how do we create the fear of detection? How do we do that? And I think clearly the way to do it is you have to establish a record as a competition authority that you are successfully prosecuting cartel conduct. Of course, that can be more difficult than it sounds. And I think that one way that jurisdictions can do it, especially jurisdictions that have just adopted a corporate leniency policy, that have just come into existence in terms of competition authorities, it is to focus on bid rigging cases. And the reason I say that is bid rigging cases tend to be smaller in scope. They require less resources. They require less experience. They're not as demanding on resources as, say, big international cartel investigations are. And a lot of people don't realize that, although they know that the Antitrust Division does international cartel investigations, that's well known, highly publicized, they don't realize that we put a lot of resources into local bid rigging investigations, especially bid rigging as to government procurement, where government agencies are procuring goods and services. Because we think that although these investigations and these matters are smaller in scope than the big international matters, they're extremely important, because we are protecting government programs from being victimized. We are protecting government agencies from spending too much money purchasing products and services, and therefore not having enough money to spend on the core mission of the agency. And furthermore, we're protecting taxpayers who fund these government programs. So it's a very important area for us, and it's an area that I think other jurisdictions can focus on and establish a record of being successful in terms of prosecuting cartel conduct. And then with respect to the significance, the severity of sanctions, the Antitrust Division's view has always been that the greatest deterrent to cartel conduct is imprisonment of individuals. And so that has always been our position. We feel that the individuals have to be the focus of the key aspect of our deterrence efforts, because it's the individuals who are in the secret room, individuals who are making the agreement. It's through the individuals that the company is engaging in a cartel. And so we think imprisonment is the way to send that signal. And also, the threat of imprisonment is a severe sanction, and one reason why a company will come in to get leniency, because they're concerned about their exposure of their individuals, and they want to make sure that the individuals, in addition to the company, get leniency and are protected from possibly having to serve a jail term. So the reality is, however, that because different jurisdictions have different legal systems, they have different cultures, They have different circumstances in a variety of ways. Not every jurisdiction is going to prosecute individuals, but jurisdictions can take other actions that are significant sanctions against individuals. For example, they can adopt employment bans where the individual is banned from working in a particular industry, or where the individual is banned from working in a particular role in the industry. They can also fine the individual on the condition that that fine, which will hopefully be a significant fine, cannot be paid by the company or cannot be paid by a third party. It has to be paid by the individual, him or herself. So there are other sanctions that can be imposed on individuals that will create the dynamic that we're talking about, where you have the concern about detection, and that's combined with a significant sanction, which we believe should be a significant sanction as to individuals. So that's basically the summary of what I talked about earlier today, and I think gives you the key concepts that I discussed.